unexplained wealth, salary violations, bank records, and financial forensics. Any member who wishes to make a manifestation on this article?
Yes.
Congressman Rufus Rodriguez.
Mr. Chairman, here there is no statement, there is no proposition that one of the 6 grounds or more of the Constitution has been violated. Unexplained wealth is not in the Constitution. Salary violations is not in the Constitution. Bank records, financial forensics are not in the Constitution. However, let's take this. As probably I will now be able to just be able to assume, arguendo, that this may be to be able to support the betrayal of public trust. But Mr. Chairman, the problem with Article 4 is that there are absolutely no recital of facts constituting the offense charge, because we don't even have the offense charge. There is no statement of either culpable violation of the Constitution. Second is treason. Third, Mr. Chairman, is bribery. Fourth is graft and corruption. Fifth is other high crimes. And sixth, betrayal of public trust. Nothing in Article 5 of this fourth impeachment complaint. So clearly, there is no recital of facts. How is there unexplained wealth? There is no statement that the Vice President received so much money and has deposited so much money, has acquired so much properties, that there is unexplained wealth. Because this is also defined under Republic Act 1379, RA 1379, which is the civil forfeiture of illegally acquired wealth. Nothing. Nothing on this. Also, there is no statement of which SALN violations. Because in the third complaint, it was the SALN from 2007 to 2017 as she was vice mayor and mayor. But nothing. Nothing on SALNs from 2022 when she became president, Vice President, June 30, 2022 up to now. Nothing. There's no statement here. So, the second will again fall, the violations. Bank records. What bank records are you talking about? There is no attachment of any bank record or any statement of bank record. And then, financial forensics. This is something that is a matter of evidence, not as a ultimate statement of facts. So therefore, Madam Chair, that is why, you see, that is why they are requesting, if you go to page 59, you look at this. This is not a recital of facts. What does it say? It's 59. 247 paragraph. To determine the existence and extent of unexplained wealth and SALN violations, I respectfully request, Attorney Cabrera, respectfully request that the Honorable House of Representatives, through the appropriate committee, take the following actions. Issue subpoena. We are not yet there. The only problem with this is a clear request for a fishing expedition against the Vice President. So very clear. In Article 4, there is nothing that recites facts that will lead us to say that there is a sufficiency of substance, and therefore, very clear, what do they ask here? To order preservation of vault inventories. Can you imagine that in this particular proceeding, already asking for us to fish? And then, we also authorize coordination with COA, the Bureau of Internal Revenue, Anti-Money Council. But they have to first recite the statement, ultimate facts constituting. There is none, Madam Chair. So therefore, clearly, this particular, by a very face on the face, in the four corners, under positive law, where you can only look at the four corners, like in this case on finding substance, we have to look at the statements in the four corners of the document. And there's nothing there about all of these allegations. So therefore, Madam Chair, Article 4 as Article 5 as Article 4 false. there is no sufficiency in substance. Thank you, Madam Chair.
The
Madam
Honorable
Chair.
Po and then the Honorable Suntay.
Madam Chair, of course, with due respect
Madam Chair,
to the previous
may I be
speaker,
allowed to answer after Congressman
Yes,
Suntay?
you will be called after the Honorable Suntay.
Madam Chair, with due
You may
respect to my colleague and someone I believe is very knowledgeable when it comes to the law and the Constitution, I'd like to cite that Article 11, Section 17 of the Constitution is clear that public officers are required to file a true and complete statement of assets, liabilities, and net worth. And this is not a minor administrative requirement. It is a constitutional duty grounded in public accountability. So at this stage, our task, Madam Chair, is quite limited. We're not determining guilt, and we are not conducting a forensic audit. We're deciding whether the allegations are ultimately true. So we are determining sufficiency and substance. And what I have noticed and what I have observed here in this complaint is that as our honorable colleague has mentioned, there seems to be no salin copies, no bank records, and no forensic financial reports attached to this complaint. However, I wouldn't say it's a fishing expedition. So if I may ask some points of clarification to our sponsor, our colleague, Rep. Abante, I'd like to ask...
The endorsers' attention are invited regarding questions to be raised by the Honorable Po.
To further give, I guess, light to this issue, may I ask what specific transactions, properties, accounts, asset increases are being cited indicative of unexplained wealth? Or maybe are there particular salin years where material omissions were alleged?
May we hear from our endorsers?
Well, to add, Madam Chair, the complaint narrates that the forensic records of the VP reveal glaring discrepancies as to the inflows and the transfers of funds in her banks as compared to her declared income in her SALN po. These discrepancies do not account by any lawful income or declaration of gifts, thereby giving the rise for reasonable inference or originated from illicit resources, Madam Chair.
You are referring to the income of the Vice President vis-a-vis what appears in her account. Honorable Ortega, may we hear your confirmation?
Yes.
Madam Chair, which account? Which bank records? Because we are here, ultimate facts. Which bank account, which bank record are we talking about here, if it's stated here? Because I have read this thoroughly 3 times already, and I did not see any.
Madam Chair.
Yeah, maybe ask first our endorser, because we have to have ultimate facts. When you say bank records, then you have a duly authenticated bank statement given by the bank.
With all due respect to the Honorable Rodriguez.
Yes, ma'am.
Let us all be reminded of the bank secrecy law. While the bank account is significant, I think we are not in the position to expect the complainants to provide specific details of these accounts in view of the bank secrecy law. And we all understand that impeachment proceeding is the only avenue by which the complainants may be able to look into this and perhaps avail of the documents necessary to support this specific ground. That is for the record. The honorable endorsers are recognized to respond to the Honorable Rodriguez.
Therefore, the need for forensic financial review, Madam Chair.
Madam Chair.
Let's go back to the Justice member who raised this question. The Honorable Po is again recognized.
So continuing on that point and manifestation, since there are no documents or bank records that could be cited, was there maybe any sworn testimony, public disclosures, audit findings, financial statements, or comparative SALN data over the years that may have been used as the basis for this ground?
The Honorable Po is asking about the specific documents or evidence in support of the fifth ground of the fourth impeachment complaint. That is in view of the bank secrecy law. What therefore are the evidence so far attached or considered in support of the fifth ground of the fourth impeachment complaint?
Madam Chair, it would not be automatic for us to be able to tell those banks no because of the bank secrecy law. That's the reason why itong pinag-uusapan natin, yung impeachment complaint na ito, lalabas po ito sa trial. We are not yet in the trial. We are just talking about the sufficiency of substance dito. Meron bang sufficiency of substance na pinag-uusapan natin? Meron. But in everything in this, I would like to tell our colleagues here, no, na this will all come out in the trial, in the impeachment court. You see? Yun po ang nais kong sabihin sa lahat.
The Honorable Rodriguez.
In answer to my good chairman, the Committee on Human Rights, there has to be a recital of facts. And in a recital of facts, there must be a reference to testimonies about bank accounts, if we cannot get the bank accounts. In other words, there has to be a nexus of the statement about irregularity in SALN and bank records by having itself the bank records, the SALNs. And so therefore, it is totally devoid of any particular recital of facts, because that is what we need. We cannot go further if there's no recital of facts constituting the offense charge. Because in fact, you know, the statement of Honorable Brian Poe that there is a requirement in the Constitution of SALN, whatever it is not in the six. To construe the constitutional provisions, you are very much limited to the enumeration. Use them generis. If it's not in the it's not in the enumeration, it cannot be a ground. So again, culpable violation of the Constitution. Second, treason. Third, bribery. Fourth, graft and corruption. Other high crimes, bitter public trust. No statement about having an inaccurate or untruthful SALN as a ground for impeachment. So that is what we have. We have to therefore have that. So just to be able to respond to the statement that there is a violation of the Constitution that is culpable. It is not, Madam Chair. In fact, those in the SALN can even be able to reform and refile a corrected one. Madam Chair.
Madam
The Honorable Defensor.
Madam Chair.
And
Thank
then
you.
the Honorable Abante.
Thank you. Madam Chairman, the most democratic way to settle this, whether there is a recital of facts or not, is to follow the rulings of the Supreme Court that in impeachment proceedings, each member is allowed to decide for himself how to appreciate the recital of facts or the evidence. And the best way to do that is by voting later on. So let's proceed and let's not stall anymore. Thank you.
We invite the
Chair.
attention of the members to the manifestation of the Honorable Defensor. There is no quantum of evidence required in determining the sufficiency in substance. And in the case of Merceditas Gutierrez, it has been upheld by the Supreme Court that the decision rests to the exclusive judgment of the individual
Yes.
members of the Justice Committee.
Madam Chair.
I think that rests our discussion
Madam Chair.
on
let me just-
this specific
Madam Chair,
ground.
let me just answer.
The Honorable Abante.
As an endorser, no, let me just answer the statement of Congressman Rufus. Of course, not being a lawyer, but of course, a very good student of law, no, legal doctrine, as explained in the case of Gutierrez, nabanggit na kanina, no, versus HOR, Committee on Justice. An impeachment complaint is sufficient in substance when it recites facts that, assuming their truth, constitute an impeachable offense and are determinative of the committee's jurisdiction. Yun po yung binanggit kanina ni Congressman Lawrence. It is not yet a full-blown trial on the merits. Because sufficiency in substance, as has been said, requires a recital of facts that assuming the truth, sapagkat lahat po ito, allegations pa lang eh, assuming their truth constitute an impeachable offense and establish the committee's jurisdiction. Therefore, an impeachment complaint that is conclusory, fact-bare, or effectively unsupported despite verification is vulnerable to being found insufficient. Yun po ang gusto kong sabihin, no? Now, pinag-usapan yung recital of ultimate facts dito. The fourth complaint that we are in